Hi, good morning all. How are you? Welcome back to L'Explanation. A tear gas, a hunger strike, a complete internet blockout. This is what we are now seeing on social medias and reading on newspapers. We know that this strike is started by our children, the NEET aspirants. They are protesting at Jantar for their rights. Being lawyer or law student, let's see what does the law says about these protests. Is this illegal or are they conducting this illegally? We know that as per Indian Constitution, Article 19 Clause 1 Clause B, right to assemble peacefully without arms is a fundamental right. So, right to assemble peacefully without arms is a right which is guaranteed under Indian Constitution. At the same time, under Article 19 Clause 3 says that the state has a right to impose reasonable restrictions for the safety of the public and unity and integrity of the nation. So, the right is there, but it is subject to a reasonable restriction. Now let's see why Jantar has a cutoff. In 2017, our National Green Tribunal has passed an order as per that the protest in Jantar was entirely restricted, saying that it is causing nuisance to the residents over there. However, in 2018, Mazdoor Kisan Shakti Sanketan versus Union of India's case, our apex court lifted that ban and they reopened the site, says that blanket bans are barred. And the apex court ordered the city police commissioner to make the guidelines to regulate it, and we are seeing the present guidelines based on that. Now let's see what a prohibitory order can do. We know that as per Section 144 of CRPC and Section 163 of BNSS, a magistrate can restrict the gathering if it is found to be dangerous for the public. But in the 2018 judgment itself, our apex court held that these orders, like reimposing these orders in every 60 days is a ban. And apex court held that while making such orders, it should be based on material facts also by applying mind. Now the question is, can the internet be banned? In Anuradha Bhasan versus Union of India in 2020's case, our apex court held that speech and trade over internet is protected under Article 19 Clause 1A and Article 19 Clause 1G of Indian Constitution. So the restriction must be published and it should be proportionate and it shouldn't be more. So the indefinite suspension is impermissible and the order must be proportionate. So it is ordered to the government to review the order in every 7 days. So it is subject to the restrictions. Next question arises, can police forcefully disperse a sleeping crowd? If we see in 2011 in Ramlila Maidan, there were protesters were sleeping and the police came to that site, and at 12:30 midnight they used the water cannon and tear gas on the protesters. So in Ramlila Maidan's case in 2012, the apex court held that the action should be proportionate, it shouldn't be disproportionate, and apex court also held that right to sleep is a fundamental right which is guaranteed under Article 21. Finally, let's see whether a state can intervene in a hunger strike. We saw in 20th of July that what had happened to Sonam Wangchuk. So what does the law says about that? If we see Under 115 of Mental Health Act, it says that the person who is committing the suicide or who attempt to commit the suicide is under severe mental stress. They should be taken care of. They should be cared rather than penalized. But if we see the latest section under BNS 224, that threatening a public officer by committing a suicide, by attempt to commit the suicide is a penal offense now. In Sonam Wangchuk's case, Delhi High Court declined the plea for forceful feeding and directs the authorities to transfer Sonam Wangchuk to a hospital and to get the medical attention and the care of doctors. So from these we can understand that peaceful protest is a fundamental right, and our children are protesting there for their right and for their voice to be heard. We hope that the authority hear their voice and understand their demands. Hear them. They are our children. Understand them. So this is what I have to say. Thank you all.